Good morning to you. Today we will continue with the Constitution. In the last class, as you know, we have seen that the judicial powers, that is, the pardoning powers of the President under Article 72, and also a comparison between the powers of President under Article 72 and of Governor under Article 161. We have also seen that the powers of President under Article 72 is of the nature of executive powers, independent of judiciary. He is not a court of appeal. Remember, he is not a court of appeal. Nor can he be compelled to give a personal hearing. Khagar Singh versus Union of India. In short, court cannot interfere with the pardoning powers of President. This is the decision of the Supreme Court. Now we are coming to financial powers of President. I have told you in the last class, a money bill cannot be introduced in Rajya Sabha and it cannot be introduced in Lok Sabha without the recommendation of the President. Prior recommendation is necessary. Prior recommendation of President is necessary for introducing the money bill in Lok Sabha. It is interesting to note, remember, it is for this reason that a private member of the House cannot put a proposal for enhancement of grants of the ministry. At most, he may sponsor a cut motion. Because if a private member is allowed to sponsor a money bill, reducing the demands for grants, then you have to get the recommendation of the President. How a private member will get? That is the reason he cannot sponsor a money bill. No private member will be allowed to sponsor a money bill for this reason. Or to substitute this provision only, the cut motion is there, which we have already discussed under parliamentary procedure. Secondly, the contingency fund of India is with the President. It is at his disposal. And he can take advances from contingency fund to meet the unforeseen expenditure of urgent nature pending authorization of Parliament under Article 267. So, contingency fund is also under his control. Similarly, President of India is to cause before Parliament laying of annual financial statement, which is popularly known as budget, and he has the powers to determine the shares of the states or income tax or certain grants for eastern states, jute, etc. Similarly, he can appoint every 5 years under Article 280 of the Constitution a finance commission to make a recommendation regarding the distribution of revenue, the shares between union and the state. These are all the financial powers. Then miscellaneous powers. He has to make regulations to determine the number of members of UPSC and their tenure, conditions of service, and also he has to make regulation specifically the matters in which UPSC consultation is not necessary. Certain selections are outside the purview of UPSC. Those regulations are to be made by President of India. That is, in which cases consultation of UPSC is not mandatory. That is exemption to UPSC consultation. Those regulations are to be made by President in consultation with UPSC. Similarly, President may refer any question of public importance involving a question of law or question of fact for the advice of Supreme Court under Article 143 of the Constitution. He may also authorize use of Hindi as ultimate official language in the light of the recommendations made by Official Language Commission, which he has to appoint from time to time. These are all the powers of the president: financial powers, miscellaneous powers. We have seen judicial powers. We have seen executive powers. We have seen diplomatic powers. We have seen army powers. We have seen ordinance making powers. So we have seen all these powers. The another power which he is exercising is the emergency powers. Remember, in the constitution there are emergency provisions and there is emergency powers. So I will clump both of these. There is no need to first, as a skeleton information about the power, emergency powers of the president, and then detailed provisions of emergency provisions. So that is not necessary. We will combine both. That is in part 18. Remember, the emergency powers of president, that is the emergency provisions, have been given in part 18 of the constitution. The part 18 of the constitution stipulates three kinds of emergency. One is national emergency, second is president rule or state emergency or constitutional emergency under article 356, then financial emergency under article 360. These emergency provisions assign to president some abnormal functions and extraordinary powers. The consequences of these powers are so sweeping that they enable the federal state to acquire the strength of unitary system as and when the exigency demands. Of course, as and when the circumstances warrant, the president can acquire. Now, these emergency provisions have been welcomed by many constitutional experts and scholars like Alladi Krishnasamy, who said the emergency provisions are very life breath of the constitution. At the same time, many other scholars like H.V. Kamath, they have criticized these emergency provisions as charter of reaction and retrogression. So both are there. Some people are welcome, some people have condemned. But the fact remains, after due consideration, they have been incorporated in the constitution. Now remember, this part 18, the emergency provisions, have got only 9 articles. Only 9 articles. Though these articles carry heavy constitutional weight, giving immense scope for good use, at the same time for mischief. That we will see when we deal with one by one. As you know, why these emergency provisions are there? The federal government, the federal constitution is always weak. Why? Because of the division of powers. The powers are divided between the union and the states. When the powers are divided, automatically it becomes weak. That is why every federal constitution, there will be a system or mechanism where the unitary features are thrusted upon during emergency. Where the circumstances require, automatically the federal constitution will become unitary constitution. Similar is with our constitution also. Now first let us see national emergency. Article 352, 353, 354, 358 and 359. These are all the articles which govern the national emergency. The main provisions of national emergency is very, you have to see this prior to 44th Amendment Act 1978 and after 44th Amendment Act 1978. As and when it is incorporated, it was added, I will explain. What is the article says? when the President of India is satisfied, remember, when the President of India is satisfied that a grave emergency exists, remember, most important, the term emergency is used in the article only here, not in President Rule 356, not in Financial Emergency 360. In the article, in the body of the article, the term emergency has been used only in Article 352. First thing, from examination point of view, PT point of view, you should remember. So, when the President of India is satisfied that a grave emergency exists whereby the security of India is threatened, remember, threatened by war, external aggression, or armed rebellion, he may proclaim emergency in respect of whole of India or part of India. And this proclamation can be varied or revoked by President. So very simple, 3 line and 4 line. First point you should remember is actual occurrence of war, external aggression or armed rebellion is not necessary. Instead, imminent danger, there is a possibility, imminent danger of such an occurrence is enough. So, second point you have remembered. Third point is the proclamation can be issued by President only, underline only, when the Prime Minister and the Ministers of Cabinet rank communicate the decision in writing to the President. Then only the President can proclaim emergency. Most importantly, understand the term cabinet has been used only in this article. So, original constitution did not have the mention about cabinet. Fifth point you should remember. And prior to this provision, that is the proclamation can be issued by President only when the Prime Minister and the Ministers of Cabinet rank communicate this decision in writing. This was added through 44th Amendment Act 1978. The legacy you should understand. What is the legacy? In 1975, emergency, that is I think 25th June 1975, that emergency was proclaimed by President Fakhruddin Ali Ahmad on the advice of the Prime Minister. The Shah Commission recommendations, the Shah Commission evidences revealed that Mrs. Indira Gandhi did not conscientiously consult all the ministers. Some ministers revealed that they were kept dark. They were kept in dark about the proposed emergency. So, as a safety valve, on the recommendation of Shah Commission, this provision has been added that President can proclaim the emergency only on the written advice of Prime Minister and the Ministers of Cabinet rank. This is most important. Next point you should remember is, originally, prior to 44th Amendment Act, the reason, the grounds are, number one, what are those? War or external aggression or internal disturbances. Prior to 44th Amendment Act, 3 grounds were there in the Constitution: war, external aggression or internal disturbances. So, internal disturbance means if there is a law and order problem in Chandni Chowk of Delhi, it is an internal disturbance. So, taking advantage, allegedly, taking advantage of this position, Mrs. Indira Gandhi has promulgated emergency. So, on the basis of recommendation of Shah Commission, the internal disturbance has been replaced by armed rebellion. So, remember, now read it. When the President of India is satisfied that a grave emergency exists whereby security of India is threatened by war, underline, external aggression, underline, or armed rebellion, which was replaced in the place of what is known as internal disturbance, he may proclaim emergency in respect of whole of India or part of India. This proclamation can be varied or revoked by President. This is the operative portion. So, the emergency can be declared only under three circumstances: war, external aggression, armed rebellion. Again, I repeat, prior to 44th Amendment Act 1978, instead of armed rebellion, it was internal disturbances. These internal disturbances was replaced by armed rebellion through 44th Amendment Act 1978. During Shah Commission inquiry, it was revealed that Mrs. Indira Gandhi in June 75 took advantage of the small disturbance in Delhi and imposed national emergency. Therefore, armed rebellion was inserted in the place of internal disturbances on the basis of recommendation of Shah Commission. So, similarly, next provision. Similarly, the provision that the emergency can be proclaimed only on the written advice of Prime Minister and the Cabinet rank ministers, also added through 44th Amendment Act 1978, because it was revealed that in June 75, Mrs. Gandhi apparently did not consult her cabinet colleagues and imposed the emergency. As a safety valve, this provision has been added on the recommendation of Shah Commission through 44th Amendment Act. So, this point you should remember. Now, this proclamation, now come to the procedure. This proclamation made by the President of India should be approved by both the houses of Parliament within a month. Remember, within 1 month it should be approved. If Lok Sabha is dissolved within this 1 month, or if Lok Sabha is in the state of dissolution, Rajya Sabha will approve it first and Lok Sabha will approve it within 30 days from the date of reassembly after general elections. Now, how the proclamation is approved? The proclamation will be approved by special majority by both the houses. What do you mean by special majority? Absolute majority plus 2/3 majority of the members present and voting. Once a proclamation has been approved, that proclamation will be valid for 6 months from the date of proclamation. Again, for further extension, similar proclamation has to be moved and passed by both the houses of Parliament by similar majority. During the extended period of 6 months, the Lok Sabha is dissolved, or it is in the state of dissolution, the Rajya Sabha will approve it first and Lok Sabha will approve it within 30 days from the date of reassembly after general elections. So, the second point, the 6 months, and there is no time limit for national emergency being ended. In other words, 6 months extension can be given for any number of times. There is no restriction at all. But every time the proclamation has to be approved by both the houses by special majority. Remember, by special majority. So 6 months extension can go on indefinitely. However, there is again added through 44th Amendment Act 1978. In this case, the provision added was the 1/10 of the members of Lok Sabha. 1/10 of the members of Lok Sabha can ask the President or the Speaker. If the House is not in session, President. If the House is in session, Speaker. The members, 1/10 of the members can give notice asking the President or the Speaker, as the case may be, to convene the session. And the session should be convened either by the President or Speaker within 14 days. Within 14 days, they can convene the session. And in this session, convened for Lok Sabha, if a proposal has been passed ending the national emergency by simple majority, please note simple majority. If a motion of disapproval of emergency has been passed in Lok Sabha by simple majority. What is simple majority? The majority of the then members present on voting. On the basis of this resolution, President will end the national emergency. So remember, very important point you should remember, Rajya Sabha has no role. The provision is only for Lok Sabha. And what is they are saying in the kindly go through the constitution, that is notwithstanding the aforesaid provisions, notwithstanding the provisions mentioned in Article 352, the Lok Sabha can pass a resolution by simple majority of the members present on voting, ending the national emergency. On the basis of the resolution, President of India will end the national emergency. So remember, most importantly, there is no role given in the constitution for Rajya Sabha for ratifying the resolution or supporting the resolution. Now we will come back to what is known as the effects of emergency. What are the effects of emergency? First is, the executive powers of the union will extend to give directions to any state as to the manner in which the executive power of the states are to be exercised. This is the first effect. That is, the union executive will get full powers to give such directions as deemed necessary to the states, how their executive powers are to be exercised. Secondly, the union government can alter the financial arrangements between the union and the state. That is, all the provisions of Article 268 and 269 stand suspended. Distribution of revenue will be completely in the hands of the union. This is the second consequence. Thirdly, Article 19 shall stand suspended if the emergency was declared on the ground of war or external aggression. In other words, if the ground is armed rebellion, there is no automatic suspension of Article 19. Most important. Third one. Fourth one is the right to enforce fundamental rights. That is, the right to constitutional remedy can be suspended by President in respect of any right, and except Article 20 and 21, which I have already explained when we discussed fundamental rights. That is, the right to move Supreme Court for enforcement of fundamental right. We have 6 freedoms. At a time, not all freedoms. If the president wants, he will reduce only 1 freedom, 2 freedom, 3 freedom. It is not necessary that he should take away all the freedoms, all the rights. Not necessary. It is any right can be suspended for enforcement of fundamental right, except Article 20 and 20. 20 and 21 cannot be touched. Similarly, Parliament may by law extend the term of Lok Sabha for 1 year at a time during the period of emergency. However, the term cannot be extended beyond 6 months after the expiry of emergency. Beyond 6 months after the expiry of emergency. So, this is the 6th point. Secondly, the Union Parliament can make law on any state subject. In other words, the distribution of legislative powers given in Schedule 7 is changed during emergency. The lawmaking powers of the state is not suspended. Instead, the states can also make law, the union can also make law, but the union law will prevail over the state law. That is, the union gets overriding powers than the state. So, if there is a clash between a union law and state law, even on state subject, the union law will prevail over the state law. So far, the national emergency has been enforced 3 times. In October 1962, emergency was first invoked when China attacked India. You know. This emergency continued till January 1968. As a result, the second invocation was not needed at the time of our war with Pakistan in September 1965. For the second time, the national emergency was in force in December 1971 when we had another war with Pakistan. Now, this emergency continued. The third emergency in June 75, for the third time, the national emergency was imposed and it remained till March 1977. Kindly see, there is one small thing to be noted. The second and third was in continuation, but the ground of second emergency, that is 71 emergency, was war or external aggression. Second, that is June 75 ground was internal disturbances. So that ground was different. So the second time was invoked. That is, the technically third time was invoked. The ground was external aggression in 1971. That ground was ended. No formal revocation of emergency. There is no formal revocation of emergency after 1971. It continued, and June 75 emergency was in continuation of 71 emergency, but a separate proclamation was made because the ground for emergency was different. Kindly note this point. So we will continue with the class in the next. Tomorrow we will deal with other two emergencies, that is president rule and as well as the financial emergency. Thank you very much.